For professional, knowledgeable real estate service you can count on, call the Dan Gemus Real Estate Team. For solid real estate information and advice you can trust, listen to the Dan Gemus Real Estate Show.
Compliments to the show. You're really hitting on the subjects and you're telling the truth. I appreciate you.
Now back to the show with broker owner and host, Dan Gemus.
All right, everyone, welcome back to the show. It's time for our legal segment with a good friend, Christian Janisse from Simplyclose. Hey, Christian, how are you?
Hey, Dan, I'm doing well. How are you?
Well, fantastic. Thank you. So, listen, I was telling you earlier during the break, we love the newsletters you put out. You do a great job. And in those newsletters, you often, refer to case law. So various things that have happened, in real life, as we like to say, because you often will talk about situations and how they might play out. But it's great to actually hear of true examples. So this week, you have something you want to talk about with regards to a few different things. One of them being deposits on new builds.
Yes, it's actually deposits in general, just deposits when you're buying a property. And then the other thing is just, when you're going into an agreement, there's this thing called the entire agreement clause, which I'll touch on. Okay. But basically for this case, because I tell a lot of people, this is what the law is, this is what the cases say. And then I feel like some people just think, oh, that will never happen to me. Sure. Or, maybe they're just being dramatic lawyers. But in this case, you have somebody who bought a property for $3,350,000.
Okay.
Their deposit was $502,500. So it was about 15% of the original purchase price.
Okay.
And basically the long story short with the case was that the person wanted to back out. Now, why they wanted to back out, they claim it was because the house was supposed to be 4,300 square feet above grade, but it was actually 3,000 square feet above grade. The buyer also said that the finishes at the property were lower quality because the advertising said that it was a premium or a luxe, but in fact, It was very low quality.
I'm assuming they would have seen the property before buying it in person.
In this case, it was a new build. So they didn't see it.
Okay, I see. Okay, all right.
And then the other thing that she said was that her English was limited, so she didn't fully understand everything that she signed. That was her Hail Mary at the very end.
Okay.
So few things that happened in this case. She wasn't able to close, or she refused to close. So the first thing she said was, well, you lied about the square footage. And these contracts can be very long. I know they can be very daunting. She obviously didn't get legal advice before signing it or have anybody look it over. And she initialed next to a spot that said that it was 4,300 square feet, including 1,100 square feet for the basement.
Okay.
So she basically just outright lost on that one.
Yep.
The second thing was that the premium or luxe features, that's just marketing talk. Like, what does that mean?
Yes.
What are you actually getting? And so in every contract, there's usually an entire agreement clause. So in the standard ORIA form, like the form that the realtors use, there's an entire agreement clause. And what that clause basically says is that anything that's in this contract is like the gospel. That's what we've agreed to. So anything that we've discussed outside, anything that's in the MLS listing, anything that we promised or, said, hey, this is a great property, this is a great value. Turns out it's not a great value afterwards. You can't turn around and say that that's enforceable.
Sure.
Basically, once it's in the contract, that's the entire agreement between the two parties. There are some limited circumstances in the case of fraud, like if somebody lied to you about something.
Sure.
But yeah, so whatever's in the agreement is what's enforceable. So if there's something that people are concerned about or that they're hesitant about or that they just want to be sure of, put it in the agreement, even if it's something as silly as, the washer and dryer are going to be there in good working order. Just double check everything and make sure that it's in the agreement. Now, the other thing that she argued was that the deposit was too high and that it wouldn't be fair because in this case, the builder actually didn't sell it for less. So they didn't have any damages, at least not at the time of the case. So she said it would be unfair for the builder to retain $500,000.
No.
And so the judge said, so there are certain cases where there's relief from forfeiture, which is just that the deposit is disproportionate to the damages. But anything up to 20%, cases have said, no, you lose the deposit if you can't close. Doesn't matter what the reason is. So in this case, even though it was $500,000, she lost it all. And the other thing about the English, or just saying I didn't understand what I was signing, they said not an excuse.
Right.
You should have known to get something signed. You initialed next to all of this stuff. You had no, you didn't say anything when you signed it. Now,
Yeah,
when
you
it
can't
comes
plead
to
ignorance. Yeah.
yeah, exactly. So you can't sign the contract and then say afterwards, oh, hey, about that contract, I'd like to make this change. Or
Well,
this
could you
isn't
imagine
exactly
if that was the case? Every time someone didn't like something, they would just say, you know what? I didn't really fully understand what I was signing. Well,
which is exactly what the courts say.
yeah. Get legal advice then, if that's the case.
Yeah. And so in this case, like she said that she was supposed to get like luxe finishes, and the court said, well, that's just marketing talk. Like, what are they going to say? You're going to get crappy finishes? So she should have been a little more specific, or asked more questions, or, maybe went and visited some suppliers or did something to make sure. But a lot of times, particularly with new builds, they're not being built for a while. So you're signing it sight unseen, basically.
Yeah.
And then you could be disappointed afterwards. Like you said at the beginning, if you see the property, you can see what the finishes are.
Sure.
But anything that you want in the agreement, you should put in there. Like anything that you're concerned about. I've seen even just like some of our own clients with things that are arguably either a chattel or a fixture, kind of in the gray area, and it's not in the agreement, and then you're fighting about it. Whereas if you just put in there, that bookshelf that's fixed to the wall is staying.
Yeah, appliances, here's the serial numbers of the appliances. They don't get switched out. You can go on and on for sure.
Yeah. So I thought it was interesting because basically this is like a telltale case that we deal with all the time where people are disappointed, or I don't know, maybe there was another reason they couldn't get financing and they were just trying to get out or something. And yeah.
I was going to say, Christian, do you find in Canadian law, people watch TV, right? They watch a lot of TV, and they're mostly American shows, and people will sue for this, sue for that, sue because whatever. I find in the experiences I've heard about or I've been educated on, Canadian law, pretty much there's more common sense at play than the Americans seem to have it. Do you find the same?
Yeah, it's definitely not as litigious as America. It's basically you are entitled to get back whatever your damages are. Like there's not a lot of frivolous lawsuits in Canada, and the judges are, they don't always get it right, but they're very reasonable. And so they don't usually, just award like these, like what you see in the States where it's like there's millions of dollars because somebody slipped and, sprained their ankle out front of your restaurant.
Right. I have this is a completely different topic, but a text has come in from a listener, and it's a whole different topic, but I'm wondering if you can tackle it before we go. So the text says, what happens if a seller passes away before closing? So I'm assuming you have a firm deal. You buy the house on paper, but it closes in a month, say, and the seller passes away before they sign the final paperwork for the closing at the end of the month. What would happen in that case?
Basically the person who passed away, their estate. So assuming they have a will, if they don't have a will, they should get a will, or they should have gotten a will. Yeah. They should have gotten a will, because a will make it much quicker for you to be able to sell the property. But you just have to apply to the courts to get the probate or the certificate of estate trustee. If you have an agreement of purchase and sale, you can expedite that so that it's only a couple weeks. So depending on where the closing date is, it might just have to get delayed by a couple of weeks, because once they pass away, you have to go through the probate process. And as much as it sucks for the buyer, it's just that the seller there's no seller to sign the closing documents and transfer over the property.
Right. Now, there's no risk per se to the buyer, maybe just delays, right? But there's no risk that they could no longer get that property. The agreement was signed.
The property, the agreement is still valid itself. It's just the person conveying the property is no longer the actual person who signed it. It's the representative, because they've passed away. So the agreement itself is still fine, because that person clearly had an intention to sell that property. So the estate trustee can't turn around and say, oh, I think I could get more if I relist it, and this agreement's no longer valid. I don't think that would fly.
No will in place. How much of a delay would that put into play?
like up to 3 or 4 months.
Yeah,
because if you, yeah, this is the thing with the wills. So if you wills are relatively inexpensive, a couple $100 to get one. You get the wills and the powers of attorney per person, and they expedite things. Even if you don't have, like, if you own a house, you should essentially have a will. We had somebody, unfortunately, who was younger, like in their 30s, who passed away suddenly, who didn't have a will, and it was a whole process because the house was in the deceased name only, and we had to transfer it to the spouse, and it was a whole process that was much longer than had they had a will. I'm assuming they thought, I'm young, I'm probably not going to die, and that's, it's unfortunate. So everybody should have a will.
Everyone should have a will, no doubt about it. You're right.
If you own a house,
yeah. Well, quite frankly, if you have kids, if you have any possessions, yeah, like you said, it's pretty inexpensive to have it done and just get it taken care of. So,
and it saves you tons of money afterwards, because in terms of getting the certificate, you just apply, and it's much more, it's quicker. So if it's quicker, it's cheaper. Whereas if you don't have a will, you have to like send out notices to the public, and it's more work. It's more onerous on the estate trustee to try and prove that they're the person entitled to the will.
Okay, so what have we learned today? We've learned get a will.
Yeah, get
powers of attorney.
Sure. We can help with the will.
If you have an agreement in writing and you send a deposit in, and make sure you're aware that you can't just back out, willy-nilly, just because you change your mind.
Yes, which happens a lot. Also, just because you didn't pay the deposit doesn't mean that they can't get the deposit from you.
That is definitely one of the biggest myths out there. Okay, you know what? My deposit's due, on acceptance. If I just don't give the deposit, then I'm good to go, and I don't have to, close the deal. That's one of the biggest, misnomers for sure.
Yeah, no, it's crazy.
Wow. Well, there you go. Well, Christian, if anyone has any questions out there, what's the best way to reach out to the team over at Simplyclose?
They can email us at hello@simplyclose.ca or call us at 519-997-3775.
Fantastic. Thank you, sir. Appreciate it. We will we'll see you again in a couple weeks.
All right. Take care.
Now you got it. You too. That's Christian Janisse with Simplyclose Real Estate Law. Great guy, and lots of very good information there. So go out there, get your wills signed. Very, very important. We're going to take a break. We're going to come back, and we're going to answer some more listener questions. But what do you say we give away a gift card for the Richmond Popcorn Company right now? You can give us a call at not a call, a text. No, call 51. Hello, long day. 519-792-2559. Caller number 9 gets the gift card today for the Richmond Popcorn Company. 519-792-2559. And if you win the gift card, you can use that gift card at either of the 2 locations for the Richmond Popcorn Company: the original downtown Amherstburg location right on Richmond Street, or the new Tecumseh Mall location right in Tecumseh Mall, right in the middle of the mall. Can't miss it. Okay, so right down the hall from the food court, and all free taste testing there. You can see all the flavors on their website as well, richmondpopcorn.com. Caller number 9 gets that gift card. Lots more to come right here on the Dan Gemus Real Estate Show.